wonder that so many sheriffs around the country are refusing to put their deputies and the public in harm's way to enforce a confiscation order that has a high possibility of being wrong and that can easily be obtained by a spurned former dating partner or a distant relative. As detailed in my written testimony, government attorneys sometimes discourage people from having counsel at these hearings, even at their own expense. A former Connecticut prosecutor bragged about how he talked respondents out of using lawyers. Colorado is taking steps to prevent such abuse by making court-appointed counsel available to all respondents. But a lawyer can't do much if she is prevented from cross-examining adverse witnesses. Some states eradicate the right of cross-examination. The accuser and witnesses supporting the accuser need never testify in court, where they would be subject to cross-examination and where the judge could observe their demeanor and make a decision about credibility. Instead, persons can simply submit an affidavit. In some states, the petitioner will never be seen by a judge or by opposing counsel. They can make a telephone call at an ex parte hearing and then immunize themselves from cross-examination at a later hearing simply by filing an affidavit. States that thwart cross-examination, promote unnecessary no-notice, no-knock raids, may have or leave innocent victims without a civil remedy for false or malicious petitions, or which deny other core elements of due process, should not be rewarded with federal funding. Federal funding should support best practices and not the worst. Thank you.
Thank you all. That was excellent. Gives us a lot to think about. Sheriff Bradshaw, if the law that exists in Florida existed before the Parkland shooting, do you think it would have mattered?
Well, absolutely. And again, I have to go back to the total picture here. And the reason I explain that is although it didn't happen in Palm Beach County, we actually dealt with the brother of Nicholas Cruz the next day. And he had made some statements, made some gestures that he was going to go back down there and finish what the brother had started. The deputies responded to that location, contacted him. My behavioral sciences unit went there, spoke with him, determined that he was actually a danger to himself or the public, and took him to a mental health facility to lodge him for 72 hours, which took him out of the system, off the street. We spoke with the parents there, asked him if there was any firearms. They said no. Did he have access to some? No, he did not. That's how the system should work. It's my belief that in Broward, you had 3 or 4 different agencies that knew this individual was a problem, knew that he had issues that he was dealing with. And again, I go back to the fact, just because somebody's mentally ill doesn't mean they're violent, but these people demonstrate mental illness issues. He had those issues. He had bullying issues from his brother. He had self-esteem issues. He had other issues that were playing themselves out, but he kept getting recycled into the system. If they would have had the type of unit that I have developed, where you have a deputy sheriff and the mental health professional as a team, and they are able to evaluate this person, and get them to the place that they need to have help, then Nicholas Cruz would have been taken out of that system and not being available to do what he had to do.
Before the current law was passed, was there any avenue for law enforcement to act?
Only if we had an arrest. Right? It's easy when you make an arrest, you seize the property.
Right. But without an arrest, the answer is no.
And that's why they kept cycling this kid back through the system.
Gotcha. Ms. Wilcox, do you think it would have mattered in your daughter's case if the California law had existed at the time?
I believe the law could have saved her life. As I said, those around Scott Thorpe, that's the man who killed my daughter, were very concerned about him. He actually had been evaluated for what we call a 5150 hold in California, the involuntary 72-hour mental health hold, and he was able to hold it together and not meet the criteria for the mental health hold. But this would have empowered his family members to take some action to remove the firearms.
Given a tool. Ms. Wyatt, how many people are in the state of Washington?
Might get in trouble for this one. Can you hear me?
There you go.
Okay, thank you. I believe
You don't have to give an exact.
Okay, I'm not
number.
quite sure. I believe it's either 6 or 7 million people. In King County, where I'm from, there's a little over 2.2 or 2.4. It's been growing
How many people have been affected by this?
by the
Okay.
extreme risk protection order.
Yeah,
I don't know the numbers statewide because we don't have a
in
very
your county.
in my county. I can tell you our unit or myself, we've worked on 70 in 2018, 70 extreme risk protection orders.
Okay.
And the vast majority were initiated by law enforcement.
Okay.
Mhm.
Mr. Koppel, what state do you think has it most right?
I think Vermont sets a good model in terms of the ex parte proceeding. In
I wouldn't
Vermont,
have picked that one, but that's good.
okay.
That's-
In Vermont, ex parte confiscation can only be ordered when the judge finds that there is an extreme and imminent risk. And Vermont also has, and confiscation can be ordered later after a due process hearing.
Do most of these states have a clear and convincing evidence standard for final disposition?
For final disposition, that's correct. But the one problem is the ex parte standards,
Yeah.
hearings can be on such low standards.
I got you. Ms. Honberg, when it comes time to kind of help people like Sheriff Bradshaw, if we pass any legislation incentivizing states to create a protective order system, how much is the mental health professional part of it? How should we focus our attention there?
Well, Senator Graham, there's no question that our mental health resources are inadequate pretty much across the country. But I agree that if in fact the removal of the firearm is related to a mental illness, that we need to be thinking about how we can link
Seems
people
like
with
Sheriff
treatment.
Bradshaw's concept makes a lot of sense. You just need the resources to make it happen.
I agree. I think that with the caveat that not all of these cases involve mental illness,
Sure.
but for the ones that do, yes.
Senator Feinstein.
Mr. Chairman, Mrs. Wilcox, it's hard to know what to say, but your strength, your grace, your comments, the cogency of those comments, my heart goes out to you. And thank you so much for fighting the fight. And I deeply believe one day people in this country are going to see the light and do something about guns. I hope I'm alive to see it, but thank you so much. Family and law enforcement were aware that the shooter in Parkland, Florida, showed warning signs, yet no one could legally do anything about it. And shortly thereafter, Florida passed extreme risk legislation, and our new colleague, Senator Scott, signed it into law. Simply put, there really is no question that school shooters can show warning signs that could give law enforcement and family members a chance to stop the next tragedy. Sheriff, do you agree and do you support this kind of legislation?
Absolutely. And I could go back and talk about the success stories we've had. We've only had to do 16 risk protection orders. Lots of times the cooperation with the family is excellent, and they'll turn over the firearms because they wanted to get rid of them anyhow. But I don't want to go back and beat this horse to death, but I cannot begin to tell you, if you're going to stop the threat and the risk assessment teams are going to work, it's imperative that you just don't rely on the law enforcement. My law enforcement officers on the team, the deputies either have a master's or a PhD in psychology or social services. But we bring a clinician from the community, I hire them, and I put them together with that team. So when I send them there, lots of times they've either dealt with those people, but they bring that expertise over and above the normal deputy. We can teach the deputy this CIT, but that doesn't give them the tools that they need. And the risk protection order is not the end all. It's just another tool in the toolbox to use to make sure that once we identify this person that has that propensity to do what they've indicated they're going to do, which this kid in Parkland did several times,
Yes.
right? And he
Right.
should have been taken to a facility to get the help that he needed. But again, they kept recycling them through the system because certain times there's not a crime that's been committed, but with the right assessment team, you can take him out of that system, get him where he needs to be, remove the firearms that he had access to, and now you've resolved that problem.
Does anybody disagree with what the sheriff has just said? I thank you for that, because coming from somebody who is a professional, and it's such a clear and definitive statement. And I don't think anybody in this room challenges that it is also a correct statement. So thank you very much. And I'm going to yield, Mr. Chairman, for others.
Yeah. Mr. Koppel, these laws that we're talking about
Yeah.
gives a judge an opportunity to take a gun away from people that are a threat to themselves or other people, but it also comes up against the Second Amendment right. And I'd quote, everybody knows this quote, "The right of people to keep and bear arms shall not be infringed." So would you agree that the appropriate level of judicial scrutiny for the Second Amendment is strict scrutiny?
It depends on the particular law, but this case, which deprives people of having a firearm in their own home, yes, at least strict scrutiny.
Okay, would you agree, same person, would you agree that it would be inappropriate to deprive U.S. citizens of their constitutional rights, even temporarily, without robust due process protections?
Yes, because the period when somebody is disarmed is a period when they're vulnerable, and without good due process protections, these laws can be abused by stalkers and other domestic abusers who want to temporarily disarm their intended victims.
Isn't it possible, Mr. Koppel, that some of the red flag laws that have already been passed by state legislatures could be held to be unconstitutional because they don't have enough due process protections in place?
Certainly, that would often depend on state laws. But for example, some states say that the right of cross-examination in all cases, not just in criminal cases, is an essential part of civil rights and due process in the common law.
This would be your opportunity to give some suggestions to them. What due process protections would you recommend for red flag laws?
In addition to the strict controls on ex parte proceedings, only having those when there's a showing of necessity and not making them a matter of default. In addition to the providing controls on ex parte proceedings, only having those when there's a showing of necessity. And I think having a robust civil remedy for people in addition to the we know providing controls on ex parte proceedings, only having those when there's a showing of necessity. And I think having a robust civil remedy for people in addition to the we know providing controls on ex parte proceedings, only having those when there's a showing of necessity. And I think having a robust civil remedy and there is in addition to the possibility of we know providing controls on ex parte very rare. Only having those when there's a showing of necessity. And I think having a robust civil civil cases. So I'd say the victim of a false or malicious petition should have the right to a civil remedy to recover attorney's fees and damages. And in addition, the whatever restrictions states have on their no-knock attorney's fees, such as in Colorado, we require the district attorney to get a warrant from the court before a no-knock. Those should apply to these kinds of confiscations as well. And unfortunately, the Colorado bill doesn't include our standard protections against no-knocks.
Okay. Various state laws and bills that are in Congress have varying standards that include substantial likelihood, probable cause, preponderance of evidence, and clear and convincing evidence. What is the appropriate standard that you'd like to see in red flag laws if Congress were to legislate?
The standard of proof at both at the final hearing and at the if there's an ex parte hearing where there's no opposition, so it should be fairly easy to win that one, should be clear and convincing evidence. And I think if we're going to have truth in legislation, when a bill says it's about extreme risks, then the standard should be a finding of an extreme risk, not a finding of some lower level of risk, or as in some legislation, merely finding a danger. Well, anti-gun advocates would probably say that every citizen who has a gun poses a danger. So that's much too low a standard. Clear and convincing finding of extreme risk, I think, would be upheld by the courts as compliant with District of Columbia versus Heller.
My last question would have to be Miss Wyatt. You mentioned in your testimony that you're a prosecutor and extreme risk protection orders. What would you agree that laws affecting the Second Amendment rights should be reviewed under strict scrutiny?
Well, you know,
And then let me follow up with this, and then this will be the last one. Would you agree that the appropriate evidentiary standard for these orders is clear and convincing evidence?
so to your first question,
Oh.
oh,
No, no, no. Back on.
sorry. To your first question regarding strict scrutiny, you know, I don't have concerns about our particular statute because due process is built in at each phase. And I can help explain that if that's helpful to the committee. Specifically, that anything that we do with law enforcement or a family member that's coming to petition is coming before the court. So there's nothing that's being done on their own accord. It all goes before a judicial officer. They are filing out a petition that's sworn under penalty of perjury. Then they're also going into court and attesting to those facts, once again being examined at the ex parte phase as well. So I don't have concerns about that particular prong in our statute. To your second question about the clear and convincing, I can just give you the perspective of our state. We have a 30-year protection order history in our state. All of our orders, our civil orders, including our extreme risk protection order, sexual assault, domestic violence, stalking orders, are all done initially by a preponderance. And that's the perspective that I offer because that's what's worked in our state.
Senator Durbin.
Mr. Koppel, have you ever met Congresswoman Gabby Giffords?
I have not. I've met her. I sat next to her husband, Mark Gifford.
Turn on your microphone. Could you turn on your microphone,
Turn your
please?
microphone.
I'm sorry. No, Senator, but I did sit next to and meet her husband, Mark Giffords, when he and I testified before this committee a couple years ago.
It's interesting, you didn't mention her name in your oral testimony, but in the written testimony submitted to the committee, you've mentioned her 18 times.
The Giffords organization, yes.
Yes. And the point I want to make is that many of us sitting at this table have town meetings. She had a town meeting on January the 8th, 2011. A gunman came into that meeting and killed 6 people, including a federal judge and a 9-year-old bystander girl, did damage to her, which she still struggles with to this day. And this gunman, whose background has been described, is, let me just read it to you if I might. I'm not going to mention his name. He doesn't deserve it. Acquaintances say his personality had changed markedly in the years prior to the shooting, a period during which he was abusing alcohol and drugs. He'd been suspended from a local community college because of bizarre behavior and disruptions in classes in the library. After his arrest, 2 medical evaluations diagnosed him with paranoid schizophrenia and ruled him incompetent to stand trial. What point I would like to make to you is Congresswoman Giffords is one of our colleagues. She was doing what we do every day. She went to a town meeting just as Miss Wilcox's daughter went to work. Her life is forever changed and 6 people lost their lives. I believe that we ought to err on the side of protecting innocent people. I hope you believe the same thing. I'm glad you didn't mention her name in your oral testimony, but I have a great admiration for her and her husband and the battle they have fought ever since so that innocent people like her, just going about their daily lives, don't become victims of someone who is clearly in a position where they should never own a firearm. I also want to say a word about your comments on domestic violence abusers. You have some pretty strongly stated views here about abusers abusing this system. And yet when it comes to the National Coalition Against Domestic Violence, they support these laws, which are a vital tool to protect people experiencing crises that make it temporarily unsafe for them to possess firearms. These are the experts on the subject. They don't buy your point of view.
Well, I support these laws too, Senator. That's why I'm here testifying. And I would just remind you that with I'm glad you didn't mention the name of the Arizona criminal. As I detailed in an article in the Howard Law Journal, there was already all the procedures in place under Arizona state law to have that person confined for mental health evaluation. The Pima County Community College, where he was attending, dropped the ball. They expelled him because he was known to be dangerous to them. And if they'd simply taken one more step, and notified a local sheriff's office
Mr.
or someone
Koppel,
like
let me-
that, he
Mr.
could have been
Koppel,
taken care of under existing laws.
Mr. Koppel, let me tell you, existing laws did not save the lives of 6 people killed by this man. What we're talking about is a step forward to protect innocent people like Laura Wilcox and others beyond the existing law, which by its definition may provide protection, in reality did not. And what we're trying to do is come to a safer conclusion. Sheriff Bradshaw, one of the things that I worry about is sending law enforcement agents to a household where we know that someone is been ruled dangerous or is ineligible to own a firearm, and asking them to come back with that firearm. That is a pretty dangerous assignment, is it not?
It is, and I'd like to go back to what you're talking about. And I cannot stress enough the importance of having these risk assessment prevention teams teamed up together, not only with the law enforcement agency, but have these mental health professionals as part of this team. All right. When you talk about the due process that they're talking about, where you need to have this clear and convincing and make sure that there's extreme danger, just having the deputy testify may be okay. But when you have that professional there that can explain it, that can say, listen, I'm a clinician, I'm looking at him, he is an extreme danger, then the court gets that sense of, yes, this is the right thing to do. This is the right order to put out there to take this firearms away from these people. And again, I cannot stress enough, the firearms are one thing, but think about it. People are using cars, knives, rocks, guns, pressure cookers. I mean, in Boston, you know, they went as far as saying, you know what, maybe we need to serialize pressure cookers and make it to where it's 21, you can't buy one. Really, folks? All right. You need to identify the people that are going to go get a weapon and keep that out of their hands. It's that simple.
Thank you, Sheriff. Well, I could just close by saying to Mr. Honberg, thank you for being here. We need to remind ourselves during the course of this conversation that mental illness is an illness. It is not a curse. There are people suffering from mental illness that are no danger to any other person on earth. In fact, are more often victims than they are perpetrators. But having said that, there are those who are likely to cross the line, and we never want that to happen if we can avoid it. Thank you.
Thank you, Senator Durbin. I could not agree more. And, you know, it's very important that we not conflate mental illness with criminality, because most people with mental illnesses are not criminals. And I also think that it's really important for us to keep in mind that with these orders, the most lives we save are going to be people who are at risk of taking their own lives.
Thank you.
Senator Corn is next. One quick question, Mr. Koppel. Is Arizona involved in trying to pass an extreme risk law?
It was up in the legislature last year, didn't pass, and I presume it's a matter of legislative activity again. But again, whatever the pros or cons on that, the man who attacked Gabby Giffords, there were all the tools there to have dealt with him beforehand.
Senator Corn.
Thank you, Mr. Chairman, for holding today's hearing, and appreciate all of you being here. I find it useful to ask myself, what problem are you trying to solve when we approach complex issues like this? Are we trying to keep guns away from people who are ineligible under current law? I'd say yes. Are we trying to keep guns away from people who are exhibiting mental illness and are a danger to themselves and others? I would say yes. Are we trying to keep guns away from law-abiding citizens that are neither ineligible nor suffering from mental illness? I would say no. Should we harden the targets that people use to attack or engage in gun violence? I would say yes. You don't hear much about people going into a police station with guns ablazing. They go into schools and soft targets. And so to me, that should help direct our thinking. With the help of a number of you, Mr. Honberg, and you in particular, NAMI, we have worked on the mental health aspects of this problem. And just so people don't think we've done nothing, let me just point to the 21st Century Cures Act and the Mental Health and Safe Communities Act, which was part of that, which was an effort to try to deal with the mental illness issue. Every time I think about Adam Lanza and his mother in particular at Sandy Hook, she knew her son was mentally ill, and she simply did not have the tools available to deal with it. She could try to get him involuntarily committed, and he'd be mad when he came back 72 hours later, and he still would be non-compliant and with his doctor's orders to take his medication and the like. So, Ms. Wilcox, I believe you've been active on assisted outpatient treatment as one potential way to address this problem. Again, if you are a son or if you are a spouse or a sibling of a person with mental illness who's an adult, it's very hard to know how to deal with that. But the assisted outpatient treatment allows you to go to a judge in a civil context, petition for essentially a court order that will require them to show up for their doctor, to see their doctor and take their prescribed medication. Do you think that is a piece of the puzzle here?
I think it's a piece of the puzzle. Our AOT scheme in California is called Laura's Law, named after my daughter, Laura. We need many tools in the toolbox. One, of course, is getting people into treatment, particularly those who are so ill that they don't recognize that they need treatment.
Right.
And that's what Laura's Law is for. Interestingly, my work on Laura's Law, which was back in the early 2000s, really helped move the legislation forward, the IRPA legislation forward in California. With both of these laws, we recognize, and you certainly as policymakers are well aware, that you have the task of balancing public safety and civil rights.
No doubt about that.
And can we find that right balance?
Sure.
And we had to make that same point for Laura's Law.
Well, thank you for that. I know my time is limited, so if you'll let me get to a couple other questions. Of course, after the Sutherland Spring shooting that Senator Cruz and I unfortunately had in our state, right outside of San Antonio, 26 people killed by a person who we know was disqualified under current law from purchasing a firearm. And what he did is he lied. And because the Air Force didn't upload the derogatory information on the background check system, he was able to get those guns and kill those people worshiping that Sunday morning at a small Baptist church there in Sutherland Springs. We passed a bill, a bipartisan bill called the Fix NICS, the National Instant Criminal Background Check System, to require federal agencies like the military to upload that information and to incentivize the states to do the same. And I'm proud of the work that we've been able to do both on dealing with mental health issues as well as the background check problem. Of course, one of the things, I think, Mr. Koppel, you mentioned that something about protective orders in domestic violence disputes. Interestingly, as I recall the law, if you are the subject of a protective order, you are already legally disqualified from purchasing a firearm under existing law. Is that your recollection?
That is correct, with some details on the facts of the protective order, yes.
Right. And Mr. Honberg, I appreciated your comments about the particularized showing in each individual case, not treating people categorically, but individually. I believe, Ms. Wyatt, you made the same point. For example, would you support these sorts of extreme violence, protective orders issue against people with post-traumatic stress syndrome?
I think thank you, Senator. I think it really depends on the particular case. Not everyone with post-traumatic stress disorder poses a risk of violence to self or others. And I think the treatment is obviously the most important service you can provide someone. But there may be some individuals who do pose risks to themselves or others, and having the availability of these extreme risk protection orders could be very, very helpful in removing the firearms temporarily from that person to basically protect that individual.
With the chairman's indulgence, let me just express my gratitude to you, Sheriff, for your mentioning the suicide problem. 60% of gun deaths are suicide. People take their own lives. But of course, there are other means for them to do so, even if they didn't have a gun. And you made that point with a car, drowning, a rope, other means. So this is more complicated, perhaps, than many of us have appreciated, and appreciate your adding that texture and context.
Absolutely. Can I make just one comment on something that you said very quickly about the background checks? You know, in Florida, if you want to get a carry and concealed weapon permit, there's a form you fill out. They give it to you. And it says, you ever been arrested? You ever been this? You ever been in a mental institution? Who in the heck's going to check yes? Nobody, right? But if you go back to the database to find out if this person should get it, that information is not in the database unless you've had something where a court of jurisdiction has actually lodged you in there, or you have some other type of system that can get that information. So if there's one thing that needs to be added to the database is the ability, and not again to stigmatize everybody that's been involved in mental health issues, but if you've had this contact with law enforcement where you've had to have your firearms taken, or you have been adjudicated, or you've had continually had contacts where in Florida it's a Baker Act where we lodge you into these institutions, somehow we've got to get around this HIPAA thing where that information is in there so the people that are issuing these licenses or selling these guns, they can check the criminal background, but they don't have that information now.
Along those lines, I've been told there may be up to 1 million adjudications in the country where somebody's been rendered a danger to themselves or others at some state proceeding that are not into the background system.
Huh?
Senator Klobuchar is next. Let me give you an example of this. Alice Boland was charged with trying to kill President Bush and a Secret Service agent. She was adjudicated not guilty by reason of insanity, assigned to a mental health facility, released. None of that got in the system, went and bought a gun and went to Ashley Hall School and tried to kill the headmaster of the gun, misfired. I think all of us would want that information into the system. Senator Klobuchar.
Thank you very much. Thank you for having this hearing, Mr. Chairman, Senator Feinstein. So about a year ago, I was at the meeting in the White House and sat directly across from the president, and we talked about these extreme risk orders. And as I said then, I come from a proud hunting state. I look at all of these common sense proposals about if they would hurt my Uncle Dick in his deer stand. They do not. And what they will do is save lives. And that includes universal background checks. And when we discussed this actual proposal, the vice president, who is sitting next to me, was positive about it. They have something like this in Indiana. And the president said he was interested in doing it, even at this point said you wouldn't need due process, which I believe he didn't mean to say. But he also said he was for universal background checks 9 times. I kept track, and we still haven't gotten this done. So I am frustrated. I hope we can get this through. But here on this anniversary month of Parkland, we still have not seen any positive changes. So I'll start with you, Ms. Wilcox. If we were to do something like this, could you just quickly talk about the importance of education so people, the citizens, know about it? I looked up your daughter, by the way, and she was a beautiful, smart young woman. I am so sorry what happened, and I am so just in awe that you were able to tell that story and help us to advance the ball on this bill. Thank you.
Thank you for that. Education's paramount with this bill. We will not realize the benefits, the life-saving benefits, unless the key stakeholders know about it. In California, we first thought we needed to be educating family members about this law. Then we realized we cannot educate family members if our courts and judges aren't ready to implement this. A family member in crisis most likely is going to call law enforcement, and they need to know. So education of law enforcement and first responders is paramount. In California, we've learned the challenge, I think, for law enforcement is how does this fill the gaps in existing law? We have our 5150 mental health hold law. The problem is there are many people who are in crisis, probably a situational crisis. They lost their job. They're angry at their boss. The wife's worried. He's talking about shooting his boss. What am I going to do? Or someone who's despondent, a new widow. The wife left the man, whatever. It's a situational crisis, emotional crisis that does not qualify for the kind of mental health prohibitions we have in California.
Okay. Thank you. Thank you. Ms. Wyatt, could you just quickly go through some of the due process provisions that you have in your state law to get at a concern some people have. And then I have a second question. For years, I've been working to pass the Protecting Domestic Violence and Stalking Victims Act. And there's a House bill that's a bipartisan companion bill. We had 2 Republican witnesses back in 2014 that agreed that extending protections to dating partners would be a good idea. As the Racine County Sheriff said, dangerous boyfriends can be just as scary as dangerous husbands. They hit just as hard and they fire their guns with the same deadly force. Could you talk about the need to update our federal laws and start with the due process protections to get at concerns that might be raised about the extreme risk bill, and then end with the domestic violence?
Okay.
Thank you.
Sure. To talk about due process, so I'm just going to walk you through what I would do, what a normal case would be like, and talk to you a little bit about that to explain it. So we would receive information either from law enforcement or perhaps from a family member that there's the at-risk individuals in a crisis. And when we're talking about crisis, we're focusing on words, actions, and behaviors of that individual. So the law enforcement officer or family member would fill out a detailed petition. I actually brought a copy if anybody wants to see what that looks like for our state. It's 5 pages long. It's similar, I would say, in some respects to doing a search warrant for law enforcement because you're attesting to these facts under penalty of perjury. So they're going to fill out this affidavit. They're going to come to the clerk's office. And I got to say that none of these processes are particularly convenient for anybody that's coming in to file orders, but this is the system. So they're going to come to the clerk's office, and then they're going to take their papers. They're going to go see the judge. They're going to go to the judge. Often ours are done ex parte because, once again, these are emergency orders, emergency situations. They're going to go into the courtroom. The judge is going to call them up, and they're going to be sworn in again. And then the judge is going to make a determination based on the petition and based on the information that they heard, whether or not it meets the standard to issue the temporary order. And then I want to say after that, then because this is being done on an emergency basis, of course, the respondent, the person who's subject to the order, has to be served. So they have to have notice of it.
Mm-hmm.
So then they appear in our state within 14 days, a hearing is set. At that hearing, our system requires the petitioner to be present to state to the court why they brought this action. The respondent is allowed to cross-examine the witnesses. He or she is allowed to call their own witnesses. And so it's almost like a mini trial in front of the court, and it varies per judge.
Okay. That's very helpful.
Okay,
Just
so-
quick answer the second question.
So to clarify, including dating partners for federal legislation for protection orders and stalking, is that your question?
Mm-hmm.
I think it's critical. We are having this challenge currently in our state to expand possibly our categories of protection orders because it was based on the federal standard, which included you had to be married or have a child in common. So it's very important to know, to include the dating partners to give those folks protection, because domestic violence defendants are the most dangerous in the whole criminal justice system. If you look at the data, they're the ones that are most likely to, obviously, if they're going to hurt their loved ones and hurt their children, they're most likely to kill law enforcement and others. And so I think it's vitally important.
Thank you so much for your work, all of you. Thank you.
Thank you, Mr. Chairman. Thank you to each of the witnesses for being here today and for testifying. The national epidemic we have of mass shootings and school shootings is a tragedy, and it is one that I believe we need to do significantly more to prevent. The state of Texas, tragically, has experienced this recently in horrific instances in both Sutherland Springs and in Santa Fe. I was in Sutherland Springs and Santa Fe in the hours following those shooters.
End gun terror. End gun terror.
Please,
Thank you,
either
Jacinda
sit down or
Ardern,
be
for your
removed.
leadership. Thank you. Thank you, Jacinda Ardern, for your leadership. End gun terror. End gun terror. Assault weapons, assault people. Enough. Enough. Do something. Follow the leadership of Prime Minister Ardern. Do something. People are dying. You're killing them.
You will get a minute back and you will continue.
Thank you, Mr. Chairman. As I said, I was in Santa Fe, I was in Sutherland Springs in the hours following those shootings, and what happened there was truly horrific. Sutherland Springs is frustrating because that crime in particular was easily preventable. The shooter in Sutherland Springs, it was already doubly illegal for him to purchase a firearm. He had a felony conviction and he had a domestic violence conviction, as well as mental health issues. But in that instance, the shooter lied about his convictions when he purchased his firearms. And tragically, the Air Force, under the Obama administration, never reported his felony convictions to the background check database. We need to do much more. And in particular, I would urge this committee to take up and finally pass legislation that I filed over 6 years ago, the Grassley-Cruz